Good evening, everyone. Welcome to our webinar. Tonight, we're going to be discussing Estate Planning 101 with some basic concepts relating to probate and estate planning in Florida. And I'll turn to my first slide here. Sorry, guys. Okay, now we've got it on the right slide. Sorry about those technical difficulties. Here is the outline of what we're going to be discussing tonight. So these are the very basics. The first question we're going to be discussing is, why do I need a will? Why are we doing this to begin with? What can a will do for you versus intestacy, which is when you die without a will? Secondly, we're going to be talking about the concept of probate. What is probate? And we'll go through that. Third of all, why do you need a revocable trust? Well, you might not need a revocable trust, but we'll talk about some reasons why you might want to think about implementing a trust rather than just sticking with a basic will. Fourth question, what about jointly owned property? This is a favorite way of some people to kind of do an end around probate without implementing a formal plan with a trust and other types of estate planning. So we'll talk about kind of the concept of jointly owned property and some things that can potentially go wrong with that, just so that you're fully informed on that one. Then we'll talk about powers of attorney and healthcare surrogates. These are pretty basic documents that everyone needs. We'll discuss out-of-state property for any of you out there who might own property outside of the state of Florida. And then we'll kind of wrap things up. So let's go down to our first slide. So first of all, why do you need a will? Well, there are several reasons. I've listed a few here on the slide. One, if you have minor children under the age of 18, you'll definitely want a will so that you can name guardians of those children in case you and your spouse, if you're married, are deceased. If you don't name guardians, it's possible that different members of your family or families could end up in court litigating the issue of who should be the guardian of these children. So this is a very important point in favor of why you would need a will. Second of all, if you have older parents, they might not need or want your money, but if you don't have a spouse or children, your parents will be your closest heirs at law, which means if you die without a will, then your parents will be the ones who end up inheriting that money. So in that case, you might want to think about drafting a will so that you can specify who should get your money upon your death. And there are other reasons, of course, that aren't listed on here. Before I get on to revocable trusts, other reasons include things like, hey, if you don't have a will, then if you die owning real estate, and this is one example, a probate will still have to be opened, whether or not you have a will if you own real estate. And if your personal representative wants to do something like sell that real estate, they can't just sell it. They have to ask permission from the court to do something like that. So they have to go to the court with a petition asking to sell the real estate, and they must prove that whatever offer they've received is a reasonable offer by pulling comps. So there's a lot of extra work that has to be done for your personal representative to do if you do not have a will. If you have a will, then you can empower the person that you name as your personal representative to do all these sorts of things for you. And when I say personal representative, that's the same thing as the word executor. Other states call it executor. Florida calls it personal representative. It's all the same thing. Going further down the slide, wills can be used in conjunction with revocable trusts, which is one of the topics we'll be discussing tonight. So if you do end up deciding you want a revocable trust, you'll still need a will. And that's because any property that you don't put into the trust will be handled under the terms of the will. And we'll get more into that in a little while. Finally, if you die without a will, again, that's called intestacy, the courts determine where your assets go. So again, our scenario of a person who's not married and has no children, their parents would get the money. If they have no parents, that money would go to their siblings, then aunts and uncles, and so on and so forth. And those might not be the people that you want to receive your money. Or further than that, there might be some people like, if you have children, if they're young, even if they are over the age of 18, you might rather that their money be held in a trust for their benefit until they reach maybe age 25 or something a little older, where they've got more experience in life and they can possibly handle, those assets a little bit more wisely. Whereas if you don't have a will, if they're over the age of 18, they're going to get that money in their pocket and do whatever they want with it. All right, so let's move to the next slide here. This is a chart showing where your assets would go in Florida intestacy law, which once again is the law that comes into play if you die without a will. So if you die without a will and you are married at the time of your death, and all your children, assuming you have children, are also the children of your spouse, meaning you don't have children from a prior marriage or a relationship, and interestingly, your spouse has no other children, then 100% of your assets pass to your spouse. But the next little box there, if you or your spouse have children from a prior relationship, then Florida law says that half of your assets go to your spouse and the other half of your assets pass to your descendants. And what do I mean by descendants? That means children. But if you have any deceased children, then that means grandchildren. So the grandchildren would step into the shoes of the children. So that's why we use that term descendants, which kind of captures everyone down the bloodline, children, grandchildren, and then of course, great-grandchildren. But again, keeping in mind, this whole chart here on this page applies only if you die without a will. It's intestacy law. If you die with a will, you can say who you want to inherit these assets, and you can be specific. All right, let's go to the next slide. I'm sorry, I'm messing this up. Okay. All right, so here we are at the next slide. So again, in intestacy, so with no will, if you are not married at the time of your death, let's look on the left here, and you have descendants, meaning children and or grandchildren, then 100% of your assets will pass to the descendants outright, not in trust. So again, we need to think about, okay, what are the ages of those descendants? So if you have no spouse and you have children who are under the age of 18, this is a big problem if you pass away while they're under the age of 18. And I'll tell you why. Because in Florida, children under the age of 18 are not allowed to come into possession or ownership of property that is worth more than $12,000. If they inherit or otherwise get property that's worth more than $12,000, then under Florida law, someone must come forward and petition to become the guardian of that child's property. And that is a court case that has to be opened. It is required that whoever is the guardian of the property is represented by counsel, which means, of course, there are attorney fees to be paid. It is a requirement that whoever is eventually named as the guardian of the property by the judge then has to do annual reports and accountings every single year, stating for what purpose the money was used and down to the very last dollar. And those accountings are audited by the court every single year. And there is a fee that is charged, of course, every single year by the court to do those audits. So it is something that I'm going to promise you that you'd rather avoid. So this applies if you have children under the age of 18 who end up inheriting your property. And so the solution to that, of course, is to have a will or a trust where you've dictated within the terms of that document that whatever anyone under the age of 18 at the very least will have their property held back in trust so that those children do not end up inheriting that property in their own name. Okay, so let's look at the other side of the screen here. So again, in intestacy, if you have no spouse and you have no descendants, okay, then 100% of your assets will pass to your parents if either one of them is still alive. If neither parent is alive, then your siblings would inherit your property, if there are any. If you have no siblings, then it goes to nieces and nephews. And I misspoke earlier. I had said aunts and uncles, but it's actually nieces and nephews. If you have any living nieces and nephews, and then if none, to aunts and uncles, and so on down the line. So again, this is where your property will go if you have no will and you have no, in this case, no spouse or children or grandchildren. Okay, let's go to the next slide. At some point, I'll get that right. Okay, so let's kind of talk about another general topic. What is probate? So probate, for those who are not acquainted with that process, is a legal process where the court makes sure that your will is valid, your debts are paid, and your assets and property are distributed according to your will and or Florida law if you don't have a will. So a common misconception I've actually run into lately is, okay, I've got my will. That's great. Now I'm done. I've avoided probate. No, unfortunately, a will does not mean that you're going to avoid probate when you pass away. A will does provide a lot of benefits, but that is not one of them. What a will do for you is, first of all, it allows you to specify who should inherit your property and in what percentages. And it will allow you, for example, like we talked about earlier, to hold back property in trust for people who might be too young to inherit it or too young to handle it. Also, if you've got children or other relatives with a disability that you might want to benefit, you can do what's called a special needs trust for them. And of course, you can empower the person that you've named as your personal representative to do a lot of things and take action on behalf of your estate without having to run to the judge every time they want to do something and ask permission. But a will does not avoid probate. Okay. We will talk about a way to do that in just a second. Probate is bureaucratic, costly, and time-consuming. So, for example, to open a formal probate in Florida, which means you have assets more than $75,000, there's a filing fee of approximately $405 to be paid. That's just to open the case. And then you've got to pay your attorney because remember, in Florida probate, you have to be represented by counsel, at least in the formal probate. And your attorney is either going to charge hourly for their time or they're going to charge a percentage of your estate. And they are entitled to charge 3% of the total value of your estate as their fee. And that can add up to quite a bit of money depending on what kind of assets you have and what the values of your assets are. It also takes, on average, about a year from start to finish to do a formal probate in Florida. So, and oftentimes it takes longer than that. So generally, probate is something that people would like to avoid. And so let's talk about what we can possibly do to avoid probate. All right. And here's the next slide talking about what's so bad about probate. So I've already gone over most of this. It can be expensive in that attorney fees are usually 3% or more, as we mentioned. This is something I didn't mention. The personal representative, whoever that is, can also take a fee of 3% of the total probate estate. Sometimes the personal representative will waive their fee because if they're a family member, a lot of times they feel like they should be doing this for free. But I will tell you, more often than not, a family member who is serving as personal representative will say that in the beginning, like, hey, I don't want to take a fee for this. I loved my mother or whoever it is, and I'll do this for free. And then at the end of the process, they say, yeah, you know what? I do want to take a fee because this has been so much work. It's taken so much time out of my schedule. And my family members haven't exactly been so grateful for the amount of work I've done. So a lot of times they will end up taking that 3%, which just comes out of your assets. All right, so it does take time. 9 months to 2 years is what I put here. During this time, at least for a part of that time, the assets will likely be frozen. We can get more into specifics about that, but that's just sort of a general. Sometimes they can do partial distributions of assets if it's going to take a long, long time, but that just depends on what's going on in the probate. Loss of privacy. This is something that a lot of people are concerned about. You might not want everyone to know what you owned or who's going to receive your assets. But if you've got nosy neighbors or friends or whoever it may be, if they want to find out who is inheriting your property and, if you had a will, who you left your property to and how much you owned, they can go to the courthouse and they can get a copy of your will. They can get a copy of a lot of the documents that are filed in this proceeding. So it's public information. And a lot of people don't like that. Loss of control, in that the judge, the probate judge, is really the person who's in charge of this process. So it's not a family member that you know and trust. It's just this judge who may or may not be, competent, at their job. They'll be supervising what happens. They're going to interpret your will. So if your will was not drafted well, like a lot of people like to do LegalZoom or whatever to save some money, and maybe they, obviously people who do LegalZoom, they don't do this for a living. So sometimes things can be drafted in a way where things are not clear. If that's the case, and we've got family members who are disagreeing over what something in the will means, the judge will be the one to decide what you meant when you wrote your will. And they'll determine how long it takes. Sometimes judges get funny ideas about things like, you know what, I've decided we have to have a hearing on this particular issue, whatever it may be. And we as attorneys may say, why do we have to have a hearing on this? But we basically have to do it if the judge wants a hearing. And then we have to notify all parties and schedule it at a time that's convenient and according to the court's calendar. So that can really stretch out how long of a time this process will take. Wills cannot plan for disability. That's another one. So certain things like revocable trusts, so again, we'll talk about that in a second, can actually help you not just after you're deceased, but if you ever develop a disability or become incapacitated, maybe as an elderly person, if you live that long, a trust can actually provide some benefits that wills cannot do that. Wills only come into effect when you're deceased. Before that, they have no effectiveness whatsoever. They don't get filed anywhere until after you die. And that is because, of course, you can change anything in your will up until you die with, of course, some restrictions if you become incapacitated. But that's the reason why they're not filed until you pass away, because people can change the wills. But they really, they're not going to do anything for you until after you die. And it's actually very common for people to not just pass away all of a sudden. Usually, especially these days, people live to be older, and sometimes they become incapacitated for a period of time before they pass away. And wills are not flexible. They cannot help you enable someone else to manage your assets. They only state simply who should receive the property upon your death. All right, let's go to the next slide here. Okay, so I've mentioned the concept of revocable trusts quite a few times, and now we're going to kind of talk about those. So revocable trust, why would you need that? Well, there's a few different reasons. First of all, and the biggest one, is to avoid or minimize probate. And what I mean by that is if you set up a trust and then you actually fund that trust, meaning you actually take the steps of transferring assets like bank accounts, savings, real estate into your trust, then when you pass away, you don't technically own anything. Everything's owned by the trust. So there's no probate to be done on those assets. So that way you can avoid the court system altogether when you pass away, avoid the filing fees, avoid the personal representative fees, avoid hearings, and all of the stuff that goes along with the court process. Also, it helps protect assets from your children's creditors potentially, but not your own. So common misconception is, oh, great, I've set up this revocable trust. That means that if someone sues me, then I'm protected from that. Unfortunately, no, there are a lot of good things a revocable trust can do for you, but it does not protect you from creditors because it is so flexible. Revocable trusts, like the name implies, can be revoked, amended, or modified at any time. So it makes them very flexible. They use your social security number as their tax ID most of the time. That's what we do because it just makes it easier for our clients. And that way you don't have to change anything with tax filings. All your income gets reported the same way as before. So there's no different separate accountings to be done. But they do not, because it is considered to be an extension of you while you're alive, then it does not protect you from creditors for that reason. But if your children have creditors, like around the time of your death, if one of your children maybe is going through divorce, where they have an ex-spouse who's pursuing them for assets, or maybe they've gotten into a car accident and someone is suing them for liability on that, that revocable trust, the trustee of that trust can hold back distributing money to that child until that time has passed so that the money does not get taken by the creditor. Additionally, and this is another big one, revocable trust can help avoid guardianship of the property. So getting back to the concept of if you develop some sort of disability or incapacity while you're alive and you kind of lose the ability to manage your own assets, your own finances, then whoever is named as the successor trustee in your trust will be able to seamlessly take over the management of those assets for you without having to set up a court-managed guardianship of the property. And this is a big one. People don't think as much about guardianship avoidance as they do of probate avoidance. But to me, guardianship avoidance is almost even a better outcome of having a trust, because guardianships can go on for a very, very long time. They're expensive because of that. A lot of time, I think a lot of us have heard horror stories about guardianships in Florida. Recently, they've been in the news. And I'm here to tell you that's not, most professional guardians are not committing the sort of wrongdoing that's made headlines. That was one professional guardian who just happened to have a lot of cases in Florida. But that being said, guardianship is a very paper-intensive process. It's expensive because you've got guardian fees, plus you've got attorney fees. So it's a really nice thing to be able to avoid because of that. And of course, when I say guardian fees, I was talking about professional guardians. It's always possible that if you have a family member who is qualified to serve as a guardian of property, meaning they don't have bankruptcies and they don't have felonies and they're willing to do it, then that's great. But it can also lead to conflict between family members. And of course, you've still got the attorney fees and the court hoops to jump through. So guardianship of property is something you'll want to avoid. Trusts can help you avoid that. They also help you maintain control of your assets throughout your lifetime, meaning even if you fund your trust with your assets that you own, you still maintain control of those assets. There's no limitations on what you can do with your own money if it's in a trust, because we will make you the trustee or co-trustee of that trust, meaning you'll have full management of control of those assets. So you can still go to the bank and withdraw your money if you want to. You can still sell your real estate. You have complete control of everything in that trust. But trusts are only effective if you fund them, meaning actually take the step after signing the trust of actually moving and transferring your assets into that trust. Okay, let's go to the next slide. So how do you fund a trust? So if you decide you want to do a revocable trust for all the reasons we've talked about, there are a few things that you'll need to do subsequent to signing the trust. And if you come to myself to do this process, we will help you with this process as much as you want us to. So first of all, real estate gets retitled into the name of the trust by a simple warranty deed. Basically, we look up the legal description of your real estate in the county records, and we draft a new warranty deed for you to sign to transfer it from yourself to yourself as trustee of the trust. Then you sign that, we notarize it, and we record it electronically with the county, just like you would if you were selling your property. And then it is officially in the name of the trust. Bank accounts and investment accounts, we usually tell our clients to do this with a letter, a form letter that you actually send snail mail. It's much easier and more convenient than attempting to walk into a branch, because sometimes the people that work at your bank branch, depending on where you bank, they might not know how to do the transfer. So it's usually just easier to do it through the mail. We can draft the letters for you. If you give us your bank information, we draft the letters. So all you have to do is print them and sign them. and send them off in the mail. There's a document called Certificate of Trust that we also draft whenever we do a trust, and that summarizes the trust provisions. So you also provide a copy of that to the bank so they have all the information they need. Now, accounts like IRAs and 401ks do not get retitled into the name of the trust, but you will probably want to think about updating your beneficiary designations for those type of accounts so that the trust can be included as a beneficiary. Now, if you're married, you'll probably want to keep your spouse first as your primary beneficiary. But if you have children, depending on their ages, you'll probably want to have the trust named as the contingent beneficiary instead of having the children named as individual people. So that's the way that would work, so that when you pass away, if you have no spouse at that time, then the money from your retirement plans actually gets put into the trust that way. Same thing with life insurance. You do not actually retitle the life insurance, but you update the beneficiary designations on those policies so that the proceeds can be paid into the trust upon your death. All right, let's move to the next slide. Doesn't it take a long time to do all this? Well, it can take a little bit of time, but like I said earlier, our firm can help you with that if you come to me. We have a process for helping the clients with this. If you want us to, we can offer you quite a bit of assistance in getting this done. And then you just have to think about, it's a little bit of homework, but you're going to feel so much better when everything's in the trust, because you'll know if you pass away, there's not going to be a probate. There will be no court involvement. Everything is pretty much done and set up for your family so that it would be as smooth a process as possible. Go to the next slide. Okay, and so this is sort of a review of how a revocable trust works. So again, you transfer your assets to a revocable trust, which you control. And that's because you're going to be the trustee. Technically, you no longer own anything. So even though you can still control it, you don't technically own it because it's not in your name anymore. So you can still buy, sell, and invest assets just like you could before. But since you no longer own anything, there's no probate. The courts have nothing to administer after you die or if you become incapacitated. So no probate or guardianship will be necessary for your property. All right, let's talk about jointly owned property. So jointly owned property, like I kind of mentioned before, a lot of people like to kind of play around with jointly owned property in order to avoid probate because they know if they add a joint owner onto a bank account or even a piece of real estate, then when they die, that person will, for lack of a better term, automatically get that property when the person dies. So it's like, hey, I figured this out. I can avoid probate by just adding a joint owner. And I understand also sometimes people do this for convenience purposes. If they've got a child who is helping pay all their bills, why not? Okay, let's just add the child as a joint owner. That way they can get into my account, pay all the bills, and do whatever they need to do because I'm getting older and I don't feel like I can really handle the bills anymore or whatever it may be. But there's several problems that can arise from this. So first of all, it can defeat the objectives of your will. If you came to me and said, Mary, I've got 3 kids. I want each one of them to share equally in my estate when I pass away. And I say, great. And we draft a nice will for you that says that. But then you put most of your bank accounts in joint ownership with one child or somebody else. That is the person who is going to receive that property when you pass away. And I've heard it before many times. People tell me, no, don't worry about that. I trust my son or daughter and they're going to do the right thing. Yes, they'll be inheriting this property after I die, but they're going to make sure that my other children will get their fair share of this. They'll write checks, they'll make it happen. And I hate to tell you, but most of the time that's not what actually happens. And whether it's, I'm not saying greed, but whether it's greed or whether it's more, hey, this child who you named as a joint owner, this is probably the same person who is in charge of your care. And if you lived a long time and this child was doing a lot of work for you, they probably feel entitled to take some kind of compensation for all the hours they spent caring for you. And you know what? Maybe they have a point, you know? So that's probably why it happens 9 times out of 10, the joint owner does not end up giving away any of that property, despite what you think is going to happen after you pass away. In addition to that, if you do put like a savings account, for example, in a joint name with one of your children, if that child has creditors of their own, somebody's suing them for some reason, whether it's divorce or something else, that creditor can now take what's in your bank account, even though that's your money, you worked for it, you saved it, it's not really their money. Their creditor, your child's creditor, can levy on that account and take that money because technically it's owned by you and the child. Well, this number probably needs to be updated. The next one is for married couples with taxable estate over 10.8 million. Make that more like 11.4 million times 2, because now our estate tax exemption is 11.4 million per person. So it's 22 point something million dollars. Then you can run into some tax trouble if you have jointly held property, which we won't get into because that's really not going to be an issue for probably 99.9% of us, including myself. So let's not worry about that one. Also, it can cause family discord after your death if you have jointly owned property. As you can imagine, kind of in some of the scenarios I've already laid out, if you've got one son or one daughter as the joint owner and everything, those other siblings are not going to be too happy about that once they find that out. And that can lead to a whole lot of resentment and fighting. And some of that could bleed into litigation. And then you've drained a lot of the assets of the estate just because people are angry. And that's never a good thing. Let's go to the next slide. Okay, so we've done a lot of talking about wills and trusts. Now let's shift focus and talk about some other documents. Powers of attorney and healthcare surrogates. These are very basic documents that everyone really needs. Anyone over the age of 18 needs to have these. Power of attorney is a document that allows you to name an attorney in fact or agent to make all financial related decisions for you if you ever become incapacitated. And I say if you ever become incapacitated because that's the reason why people do these documents. But just word of warning or word to the wise, in Florida, powers of attorney are effective upon signing. So if you're perfectly competent right now, of course, I hope you are if you're signing legal documents, and you name someone, your child, maybe to be your agent in fact under your power of attorney, once you sign that document and it's notarized and all of that, it's in effect. So if this falls into the wrong hands, that person can go to the bank and take out all your money. So hopefully, when you do your durable powers of attorney, you name someone trustworthy who won't do that to you. But just word to the wise, that's the law. It used to be that there was a choice in when a power of attorney became effective, but Florida changed that law a few years back. Might have been 2011 or 2012, where since then, all durable powers of attorney are effective upon signing. That's just the law. So just something to think about. And so you could be thinking now, all right, if I can set up this durable power of attorney and this enables one of my family members to make all my financial decisions for me, why would I need this trust? Because Mary, you said that one of the reasons to have a trust is because I could name someone to step in and manage my assets for me if I ever become incapacitated. That's true, but a trust provides a lot more flexibility. I had mentioned that trustees can hold back distributions for other people. If you said, I want my son to get, a third of my estate upon my death or a third of my trust estate, and at that point your son had developed a drug addiction problem, maybe he injured himself and got addicted to painkillers, might not be a good idea to then have the son receive a whole bunch of money that he's just going to go out and spend, on painkillers. So a trust provides a lot more flexibility because there's a lot more that you can do in a trust as compared to a durable power of attorney. Going back up a little bit up the slide, the healthcare surrogate. I don't know how many of you remember Terry Schiavo. Most people do, because it was a terrible story that happened here in Florida, but it was heard about nationwide. It's on national news. This lady, she did not have a healthcare surrogate. She I forgot what exactly happened to her, but she ended up with she had some sort of accident or something that left her in a vegetative state. And her husband, who was soon to be ex-husband, they were separated, was fighting it out in court versus her parents as to whether Terry should be taken off life support because she was in this vegetative state. And her parents said, no, absolutely not. There's still hope. We want to keep her alive as long as we possibly can. And the husband said, no, she wouldn't have wanted to live this way. We should take her off life support and just let her die. And they battled all the way up to the governor. The governor of Florida had to step in and rule that she could be taken off life support. But my point in bringing this story up is if she had had a designation of healthcare surrogate document in place, then she could have named who should be making these decisions. There would have been no court battle because she would have either named her husband or her parents or somebody else to make this decision, and that person could have made the decision and there would have been no litigation. So it is a definite necessity that everyone should have a healthcare surrogate and hopefully one backup. A living will is not to be confused with last will and testament. And I always shorten the last will and testament to will. So when I've talked about will, that's what I'm talking about. A living will is different from a will. A living will only deals with end of life decision making. So it does not designate an agent. You will need a living will to make those specific decisions about the kind of care that you would want to have at the end of your life. But you'll also need a healthcare surrogate to kind of work hand in hand with that living will. Okay, let's go to the next slide. Okay, so we're covered. We signed powers of attorney and healthcare surrogates just a few years ago. So we're good, right? Well, laws do change. First of all, we have HIPAA now. So if you've got older healthcare surrogates, they might not include the HIPAA waiver that we include in all of our healthcare surrogates now. And the HIPAA waiver authorizes your surrogate to have access to your medical records. Without the HIPAA waiver, you can have a healthcare surrogate, but they might not be able to access your records. That would really hinder their ability to manage your care. In addition to that, I think I mentioned earlier that the laws for powers of attorney changed significantly in 2011, 2012, somewhere in there. And the laws regarding healthcare surrogates changed significantly in 2015. So if you have documents that are older than that, you might want to think about updating them. And it is important to keep these documents up to date and also to take a look back at them to make sure that the people that you've named are the people that you still want to have named, because as we all know, life changes. Let's go to the next slide here. Okay, so kind of getting back to more financial and property focused. If you own property in another state, this is all the more reason that you might want to think about implementing a revocable trust. Because without a revocable trust, even if you have a will, you will still potentially have to do probate, not only in Florida, but also in that other state where you own that property. And that can be very expensive because most attorneys in Florida probably are not going to be licensed in whatever the other state is where you own property. So odds are you'll end up hiring two attorneys and you'll have to pay two different sets of court fees. And this will create a lot more work for that person that you named as personal representative in your will. So a way to avoid that problem is to transfer the title on your vacation property or investment property or whatever it might be into your trust. And then you can avoid that second probate that's known as ancillary probate. We do this sort of thing all the time. And by the way, when I say out-of-state property, I am also including timeshare. And people forget about that a lot because they're like, oh, well, I don't even know where my timeshare actually is. I trade off with other people or whatever, and I use it in all different states every year. But at least the older timeshare, as of more than a couple years ago, is titled. They have warranty deeds that go with that property. And so it actually is considered to be located in one place. So if that timeshare is located outside of the state of Florida, like let's say it's located in Hawaii or something, or Nevada, then you've got to do a probate in Hawaii or Nevada in addition to Florida. And that is something that can easily be avoided with a revocable trust. And I mentioned earlier in the slide, just mentioned this can also be done via an LLC. That's also true. So if you have an LLC that you use to own property, you could do that. You could transfer your second home in another state into the LLC. Here in Florida, I don't use LLCs as much as I used to when I was in Georgia. I'm licensed in Florida and Georgia, and I used to be based in Atlanta, and we did a lot of LLCs. But in Florida, it seems like a lot of the insurance companies like to raise rates on people if they own property in an LLC versus a trust. So I just do a lot more trust rather than LLC. But either one would work to avoid ancillary probate. Let me go down a slide. All right. So this is the last slide. So just going to encourage you all, if you're thinking about doing this, get it done today. I know it's really easy to procrastinate on these things, but just think of how good you'll feel when you finally got this done. And we've got all your loose ends tied up, and there'll be nothing left for your family to worry about. Please don't try to draft this yourself, even if you don't come to see me, and if you come to see another attorney, please don't use LegalZoom or whatever their competitor is now. A lot of those documents are not tailored for a specific state like Florida. They're just kind of done in like a general form. In Florida in particular, we have some very quirky laws down here. So it's very, very important that you go to see a lawyer and get the will or trust drafted by someone who specializes in this area, or I should say focuses on. We're not allowed to say specialize, but someone who focuses in this area and knows what they're doing as far as estate planning is concerned. Don't go see someone who does it on the side. As far as I'm concerned, if you come to see me for wills and trusts, we'd love to have you as a client. We do estate planning packages, flat fee, so we don't charge hourly for our time. And of course, our initial consults are free. We do 1 hour consults where we'll talk to you, and then I'll quote you a fee, and you don't have to go for it if you don't want to. And of course, after you do your documents, we do recommend that you look back at them every 2 to 5 years just to make sure that everything's up to date, everything is as you want it to be. So that's all that I have. Thank you for listening.
Thank you so much. We are going to take a 5-minute break to review the questions that have come in, and we'll be right back. Thank you for your patience, and I will hand it right back over to Mary.
Okay, so we've got a lot of really good questions that have come in. So I'm looking forward to answering as many of those as I can. There are a lot, so I'll try to answer as many of them as I can. And then I'd love for you all to contact me directly if you have a question that I didn't answer, or if you'd, of course, like to meet with me. And we've turned your screen back to the first page of the presentation, where you can see my phone number and my email address. So if you would like to book an initial consult with me to discuss your own estate planning or your parents' planning, you can call that number, and my assistant will schedule you on my calendar to meet with me for an hour to talk about this stuff. And of course, if you had a question, you can email me as well. So let's get into the questions here. The very first question I got is a good question. It is, we have a special needs child. What should we do or know about planning? That's an excellent question. It's very important if you have a special needs child to set up what's called a special needs or supplemental needs trust within the terms of either your will or your revocable trust, depending on what you decide upon in general. And again, I'll assist you with that decision. Or sometimes we do a standalone special needs or supplemental needs trust that's sort of its own document, especially if people have family members that might want to make gifts or contribute something to the care of the special needs child. That's easier for them if it's a separate trust. So we can always do that as well. And we can direct it. So what most people want is to have a trust that they fund upon their death, just like you would with any other child. Upon death, you want the child to receive the money in the trust. So basically the trust would sit unfunded until you pass away, unless, again, you have another family member who wants to put money into the trust for that child. And it's very important to do that, because if you don't do that and you just handle your will or trust as if like any other child without special needs, then what you would do is, if that child inherited money directly in his or her name, that would disqualify them from any benefits that they would probably be entitled to otherwise. So you don't want to do that. So it is very important that you come and see me and we talk about it and get your special needs or supplemental needs trust set up correctly so that we can avoid that problem. In addition to that, depending on your situation, you might want to think about doing what's called a guardian advocacy for when your special needs child turns 18. Because at that point, if they're not able to care for themselves and you really need to continue caring for them, you'll need to have that done legally. Otherwise, your child's considered an adult like anyone else. They can go out and leave the home, start driving a car, they can sign a contract, give away all their money. So if we haven't really talked much about guardianship in this presentation, but that is something that I do. So I can also assist you with getting named as the guardian advocate of your child at that point when they turn 18. All right, let's move on to the next question. So this was a general one. It says, so wills do not have to be recorded with the county. No, the will be filed with the court, the county court or county circuit court, really, when you pass away. Until then, no. So until you pass away, you will hang on to the original, or I will if you prefer. You can give a copy to someone else if you wish, but it does not get recorded or filed in any way until after you pass away. All right. If you have a revocable trust and you have to go to a nursing home, does the state or nursing home get your money from the trust? This is a really good question. It kind of delves into an area that we have not really talked about in this presentation, but it's good to know that this area is there and that I can help you with it. So basically, yes, unfortunately, if you have to go to a nursing home and you have a revocable trust, the revocable trust will not protect your assets from any creditors like a nursing home. So if that is a situation that you foresee that is going to happen to you or to your parents if they're getting elderly, please come and see me. I also do elder law, which is sort of a separate, it goes hand in hand with estate planning, but it is kind of separate. Elder law is basically the practice of helping people, among other things. It usually deals with guardianships as well, but I also can help people get qualified for Medicaid or VA benefits to help them pay for that nursing home stay. If they had a revocable trust, we might need to unwind that and put a different type of trust in place that will shelter and protect those assets so that your parent or yourself can actually get qualified for Medicaid and not bankrupt yourself trying to pay for a nursing home stay. So please come and see me if this is something that a problem that you think you might be having in the near future. Okay. Next question is, any tips on how to broach these subjects with retired parents? I like this question because I know exactly what you're talking about. Sometimes it's difficult to convince our parents that they need to change anything, do anything, update anything. I know there's older people, or a lot of people actually, that are kind of superstitious about this whole thing, and they think if I get my will signed, that means something bad's going to happen to me or something like that. I think you'll find that I'm pretty good. I'm pretty user friendly, easy to talk to. So I'm not an intimidating person. You can let your parents know that they can talk to me for free. They're not committing themselves to anything. I'll be happy to just kind of sit and chat with them, talk about their issues. And if they decide they don't want to do anything, that's fine. They don't have to pay me anything. I do the hour consult for free. These days we do video consults because of COVID, unfortunately. I know a lot of people enjoy meeting face to face, and I do too. That's why we do the video conference rather than phone, so that I can actually see your faces and kind of have a conversation. But yeah, that's what I would say is, hey, look, you're not committing yourself to anything. It's worth a look into it just to make sure that everything's put together so that we can avoid spending a whole bunch of your hard-earned money on a probate case or something like that. Just give that a shot. All right, let's see. Next question. Can IRAs and 401ks be updated with the trust as beneficiary? The answer is yes. Yes, it can. The trust can be a beneficiary of an IRA or 401k as long as it's drafted properly, which of course we would do for you. One more reason to not use LegalZoom, because there are rules that have to be followed in drafting a trust so that it is able to receive retirement plan proceeds such as 401k and IRA plan proceeds into that trust without getting into too much detail. But yes, it can. And that goes hand in hand with another question. If my life insurance, 401k, and IRA already have a beneficiary and a contingent beneficiary, why is it necessary to put those in a trust? Well, maybe it's not. For some people, it is because they've got children who maybe aren't old enough to handle it if they inherited that IRA or 401k proceeds at this point in time. And of course, I deal in worst case scenarios. So when you come see me, we're going to plan for the worst and hope for the best. So we're going to plan for if you die sometime soon, would you want your children to inherit your 401k? And a lot of people have like $1 million in that. So you got to think, do I want my kid who's 18 years old or something to inherit my 401k? All right, well, technically they're an adult, but do they really have the wherewithal to manage that amount of money wisely? And a lot of times the answer is probably not right now. Maybe let's lock that up in trust for a little while until they're older. And of course, and this is not something I mentioned, so I'll mention it now. Whenever there's a trust that's set up for a child or other beneficiary, the trustee can use that money for that child. They are not going to simply let the money sit there and not help the child out if they have expenses like educational expenses or medical or just daily living needs. So let's say you die, and hopefully this never happens, but if you've got children under the age of 18 who need to be cared for, no, they will not receive the money in their bank account, but yes, the trustee will pay, let's say, tuition cost for them out of the trust, and they will pay for their food, clothing, and shelter out of the trust, and all those things will be paid for out of the trust. And then at whatever age you have decided, like let's say 25, then the child can actually take the principal from the trust and put it in their pocket and go on about their day. So that's kind of how that works. All right, so someone asked, the slide on problems joint property can cause, specifically the savings account in a joint name. Would this also be applicable for a checking account? Yes. My slide on problems joint property can cause applies to any type of jointly held property. So whether it's checking, whether it's savings, whether even it's a house. I mean, I have had that happen where someone puts the house in joint name just to make it easier when they die, so that they're thinking, okay, I'm avoiding probate and it won't be a problem. I'll put the house in joint name with my son. He'll sell the house and then he'll give all my other kids their share of the sales proceeds. And again, like I kind of mentioned, that doesn't happen very often. It's not going to happen exactly as you envision it. Just that's the odds that you're playing. All right. Here's a good question. If I have one child and I make him the joint owner on my property and bank accounts, as well as beneficiary on my insurance, is a revocable trust still necessary? Well, maybe, maybe not. It just depends. You've got one child, so odds are, obviously you're the parent, you're probably going to outlive him. But then again, stranger things have happened, unfortunately. He could die first and then you're kind of back to square one. Or probably even worse for planning purposes, he could, have some sort of problem where he, like I said before, develops a drug addiction or develops some sort of disability. And then you're going to have a real problem if you've named him or her as the joint owner, because then they can either be disqualified from benefits or they can get into that money and spend it very unwisely, very quickly, which is not obviously what you're going to want. In addition to that, if they're going through a divorce or being sued, again, like I had kind of mentioned, that would expose your money to your child's creditors and they can take your money. And I don't think anybody wants that. Okay, moving on, more questions. So if you have a trust, you don't need a power of attorney in reality. Actually, you do. I realize I kind of skimmed through some of this. you still would need a durable power of attorney, even if you had a trust, because there are certain things that you need to have a durable power of attorney. Like, let's say when you're retired, you've got income streams coming in like a pension. You don't put an income stream in trust, but you would need someone named as power of attorney, agent under power of attorney, to be able to make changes. Like, let's say you had to move and change your address or something, or you had to maybe put some of your income in what's called a qualified income trust, which is a common technique that's used when people go into a nursing home and they have too much income to qualify for Medicaid. Things like that would have to be handled by the power of agent under power of attorney, because that's just the nature of the asset. It can't be managed by the trustee. Most property and assets can be put into a trust, but income is an example of something that can't be. Or if you needed, as an elderly person, you need someone to help you file a tax return, something like that, your durable power of attorney would come in handy for that, whereas the trustee really isn't going to handle that. Okay. Can you please describe benefits of a Ladybird deed for property? So this is a really good question. Ladybird deeds are a kind of interesting technique that's commonly used in Florida, and there's really only a handful of other states that use what's called Ladybird deeds. I know Texas does, I believe Wisconsin, a couple others. Basically, Ladybird deeds are a very unique type of deed. And in this deed, you are saying, I am the grantor of this property. I hereby retain the right to live in this property for the rest of my life. I also retain the right to sell this property at any time, mortgage it at any time. And upon my death, I hereby grant this property to the following grantee. And that can be your son or daughter. It can be your sister or brother, whoever you want it to be. Those can work in the right circumstances. They're not always the right call, but sometimes they can work. I've done them for more elderly people. If they kind of know, okay, I'm definitely going to outlive these people, then we don't really have a large risk of someone passing away at the same time or predeceasing someone where that can cause problems. Especially if there's only one person you wanted to leave the property to. If you've got multiple people, I don't usually do that, because then you can come into a problem with somebody, again, dies unexpectedly, and then you could have minor children inheriting part of the property, which you wouldn't want. Or I can think of any number of scenarios, but they can definitely work in the right circumstances, and I have done them before. Okay. If married, would you do a single trust or a separate trust for each spouse? Great question. I do a lot of what is called joint revocable trusts, where it's one trust set up for both spouses. And that works for a lot of people, especially if they're in their first marriage and all the kids they have are kids from their marriage, their current marriage. They don't have children from prior relationships. And they're comfortable with the idea of owning property jointly, and they're not wanting to keep certain things separate. So in that case, a lot of times we'll do the joint revocable trust, and that's not a problem. For other people, especially if they're in a scenario of a second marriage and one or more of the spouses have children from a prior relationship, that they want to make sure those children inherit their share of property when they die, then maybe they'll want to do two separate trusts and have kind of two separate sets of provisions to handle it that way. Then in that scenario, maybe we do two separate trusts. Or if I've got a couple that wants to keep things separate, then we would do two separate trusts. So it just sort of depends on your situation. Is a revocable trust only to keep any real estate from going into probate? No, it's not. Because again, if you have savings accounts in your name, and I don't mean IRAs or 401ks, I mean like straight up savings account, bank account, checking account, investment account that's not a 401k or an IRA, then if you were the sole owner of that account and you had not transferred it into a trust, someone would have to open a probate to get that account out of your name and into the name of your wife or children or whoever is your surviving heirs. So no, it's not just for real estate. Okay. All right. Well, I've got a lot of questions here. So I would love for you all to contact me. Feel free to email me with any additional questions. And again, feel free to reach out to us via phone to schedule an appointment. I'd love to hear from you guys. It's been a pleasure presenting this. I hope you enjoyed it.
Thank you so much for all of that useful information, Mary. And thank you all for joining us. Again, we will be emailing a recording of tonight's presentation, so stay tuned. Check your inboxes tomorrow. Thanks again, and have a good night.